With the increase in visa refusal, also there is an increase in the cases being affirmed at the tribunal. Now, what choices the people have in order to seek a judicial review for whatever the decision that has been adversarial at the Administrative Review Tribunal is usually Federal Circuit Court. Hi, my name is Nishant from Professional Visa and Education Services, immigration lawyer, and also MARA agent since 2015. Today I'm going to talk about things you need to know about lodging an application with Federal Circuit Court of Australia. Now, as the name suggests, the Federal Circuit Court is a federal process. Now, it has a particular time limit. Now, everyone knows now 35 days is prescripted as a legislative requirement for a person to lodge and appeal a judicial review at the Federal Circuit Court once the case is affirmed at the Administrative Review Tribunal. Usually, that if someone actually crossed the 35 days, the court might not accept the application. But there are certain ways and process that we need to follow if you really wanted to lodge an application, and it's up to the court to whether or not to accept the application. But today I'm going to talk about a few things. Now the Federal Circuit Court has a jurisdiction to hear a judicial review of the application of the migration decisions. Usually a visa refusal, visa cancellations, or any adversarial outcome by the Administrative Appeals Tribunal. What are those adverse decisions made by the Administrative Appeals Tribunal? For example, the application that doesn't have a jurisdiction at the tribunal. Second, we talked about the time limits. Now, 35 days from the date of decision on the file of your applications. Now, and what are the grounds for the judicial review? This is very important for you to understand. A court is not interested in whether or not you deserve a visa. They're not interested whether or not you have a merit. They're not interested that your visa application was lodged properly, so you deserve a visa, you're a good human being. There's only 4 major areas that you can challenge the case of judicial review. A, jurisdictional error. B, whether or not this person has been provided with natural justice, which is also known as procedural fairness in Australia. Whether they have applied a wrong law or whether or not they have actually applied a relevant law and acted beyond their legal powers. Now, these are the common grounds for a person to challenge the case for judicial review. Therefore, this particular process may be quite technical when it comes to legal background, legal jargons, and even finding out what is my standing in this situation. So usually what we tend to do as a lawyer is we request Administrative Review Tribunal for their transcript to find out what interactions has happened between you and a member. Now, finding out this could take some time, but again, you have your time limits to lodge an application within 35 days, mind you. So we have to be careful of requesting for this transcript, but at the same time lodging the application. Now, these things could be quite legally challenged. Therefore, a lot of people have lodged the application and have done the self-representation. Our recommendation is because of the technicality, the legal technicality around submitting this judicial review in the court, we would suggest using a legal representative in this situation. Now, why legal representative is important? Because a registered migration agent cannot appear unless they are a lawyer. And having a lawyer also increases your chance of framing a correct ground and avoiding any strikeout from the government. Now, usually what happens if you have a default judgment or a strikeout, the cost order, generally about $7,000 to $8,000 in this situation. That's the standard norm. But again, cost order is ascertained by the court depending on the work that the minister's lawyer has carried out in order to facilitate this case. Now, if you lose the case, usually the losing party pays the cost of the court. So again, losing a case without being properly heard is also not good for you. So to avoid paying significant amount of money, to avoid having all this cost order that you didn't know was coming towards you, this is all can be mitigated by having the right legal representative right next to you for this hearing. Thank you so much for watching. This is Nish from Professional Visa and Education Services again. I'll be back again with more news and updates in the future, but keep sharing and keep watching. Bye-bye.